Right, everybody, we'll make a start then. Good morning, everyone. My name is, as you'll see, Harry Dyson. I'm a member of the business and property team here at King's, and this is part of the commercial team's series of webinars that we are running this year. As you will also see from the slide, this talk is regarding Part 36 offers, with a particular focus in the first half of the talk on the intermediate track, and what, if any, significance that has on the operation of Part 36 offers and what we need to be doing. And the second one is the old fan favourites of just easy examples of how to essentially get a Part 36 offer wrong, and what that means, and again, what we need to be looking out for when dealing with these offers, whether you're making them or accepting them. So without further ado, then I'll go straight into the first half of the talk, which is in respect of the intermediate track. The two bullet points there on the slide really sum it up. The same strict form and content rules apply. So all of the second half of this talk applies with the exact same weight as it will do when you're on the intermediate track as it does on any other track. So there's still all that there is as it was before. So there's nothing new there. The difference comes in the consequences of the offers, which is dealt with under 3623, which we'll come on to in stages. Essentially, the key thing to remember with 3623 is that it's 3617 supplemented, and this applies and overrides 3617 in certain areas. So that's the sketch, then that's the overview. I would probably opinion that nothing dramatic is different on the intermediate track. Still, most of what you're considering, it applies across the board, but it's just when you're weighing up the finer points of acceptance or non-acceptance that you need to be aligned to the different rules. So the first one is accepting within the relevant period, of course. Timing, it doesn't matter if that's whose offer that is, whether that's from the defendant or the claimant. So you get your fixed costs by reference to the stage applicable at the date on which the acceptance was served on the offeror. So that means that if you do happen to find yourself on the tables at Practice Direction 45, the intermediate track, you'll be able to relatively easily pinpoint what stage you're in. And once you fall in that stage, the claimant will get that stage costs. A quick word, this point, the second bullet point there mentions that you're also entitled to anything that they would have been entitled to under 4560. These are the different bits of fixed disbursements and whatnot that you are entitled to under the fixed cost regime on the intermediate track. Now, this talk does not attempt to look at all those nooks and crannies of these extra costs, and it's, I think it's fair to say, somewhat neglected in the slides going forward, the fact that these costs exist. So it is the case that whenever I say that you're entitled to one particular stage of costs, you're also entitled to the disbursements reasonably incurred under 4560. So I'll flag that up now, but it's not within the, you may be pleased to hear, not within the confines of this talk to look at that in any great detail. So question arising here, what if the claimant accepts offer relating to only part of the claim? Well, if they then abandon the rest of the claim, as parties often do, then the same rules apply. Looking at how this might work in practice, I'm sure you're all by now familiar with the different stages on the intermediate track. To my mind, it is clear that it's possible to potentially hold off on the notice of acceptance until you trickle in to the next applicable stage. For example, if that 21 days puts you over the deadline to commence witness statements, for example, that might just tickle you over into the next stage. So tactically, worth keeping an eye on that, I would say, just to avoid A, that happening, or B, even worse, you have to have a full hearing and lots of costs to argue exactly what stage you're going to fall on. So I would say stay alive to that. Next is the claimant accepting after the relevant period. we see there the claimant entitled to costs up to the stage on which period expired and any additional fixed costs. Again, these are the fixed costs I mentioned. And secondly, the claimant is liable for the defendant's costs from that stage upon which period expired and any additional fixed costs. So this, I would say, runs very similar to the provisions of old when they weren't intermediate track fixed costs. In short, it will be for the court to determine the balance. And one thing that I do say about this particular provision at 36.23 is it ought to be contrasted with the rule under 36.17 when you're not on fixed costs, which says that basically the judge will do this unless it considers it unjust to do so. Whereas in 36.23 we don't have that unjust to do so provision. Rather, it's a lot more hardline and clear-cut in what the judge is going to do in terms of costs. So again, one little nuance to just keep an eye on in terms of how it's different to under 36.17. We don't have that unless unjust provision. Who knows? There may be a flurry of case law and authorities that's going to come up about this. Whether or not my view on that is going to be one shared by the judiciary, I don't know. But keep an eye on that because there is that subtle difference. So where you may have advised clients in the past, we may be able to rely on the unjust to do so provision, and that may not be applicable here. The next slide is again looking at the finer points. Whose stage is it? That's my sort of witty title there. This happens. So what happens when the claimant accepts outside the relevant period, but this is still within the same stage? And I put there the rules favour the defendant. So if we look at an example, take for an example a situation where the Part 36 offer expires just after witness statements are due. The claimant sees the other side witness statements and after a week or so thinks, well, let's quickly disinstruct our expert and save some costs and accept. But they only do so shortly after. But as you will all immediately be thinking, well, we're still in stage 5 there because we are between witness statements and experts. So if one was to look at Table 14 at Practice Direction 45, you will see that in that situation, between witness statements and experts, we're still within the same stage. The rules, as I put on the slide there, 36.239, favour the defendant in this instance, and it will be them that have that stage, and in effect, the claimant will be bumped down to the previous stage. So the rules that I put on the slide favour the defendant. Again, I said at the outset that I see these new provisions in terms of intermediate track not being a dramatic overhaul of Part 36 regime. I would say this is very much in the spirit of the Part 36 regime because there is a clear penalty for accepting outside of the relevant period, and that is any doubt in terms of who stages it is in favour of the defendant. So I would say that's in line with the rules. And again, the rigidity of these rules helps us advise clients accordingly because we can advise with some certainty what's going to happen. Next slide, of course, that was all about offers. What about following judgment? Well, where the claimant fails to beat the defendant's offer, the claimant gets fixed costs up to expiry by reference to the stage, and whereas the defendant gets their entire fixed costs minus the claimant's fixed costs as set out. So essentially, it will be an offset sort of exercise, and it's my opinion that this works this way because essentially going along the fixed tables, as you'll see, different parties will be entitled to different fixed costs, different disbursements, depending on the various factors set out in the tables. So it won't be as straightforward as allowing one party these stages and then the other party the stages thereafter. It will be a case of subtracting one from the other and seeing where the balance lays. But as I say, 36.24 is well worth reading in some detail, because it sets this out and should enable you to advise clients with a relative, and I use the term relative with some emphasis, degree of certainty. So the next one is where things gets interesting. The defendant doesn't beat the claimant's offer at trial. Of course, the claimant will get their fixed costs. But the crucial difference here is that the claimant does not get indemnity costs under 3617(4)(b). So that was one of the stings in the tail of 3617 when it comes to claimants doing better than their own offer at the end of trial. You could advise, well, you're going to get nice indemnity costs. But of course here, the costs are fixed. So that doesn't help anybody, really. So what the provisions do is give 35% of the difference between the fixed costs for the stage at which the offer expired and the date of judgment. So rather than indemnity costs between expiry and judgment, you get a 35% bump. So that is how that works. Now, just to be clear at this stage, the other goodies on offer under 3617(4), the other consequences of defendant failing to meet the claimant's offer are still at play. They're still at large, so they're all there. The fixed costs, intermediate track doesn't get rid of those, and all it does is swap indemnity costs for 35%. So I suppose that leads us to the question of, does this give Part 36 more teeth or less teeth when it comes to the intermediate track? So looking at an example, I've done an example here on band 3 complexity, which, pausing there, it's where I expect a lot of litigation on the intermediate track to be. Obviously still relatively early days in terms of that. There hasn't been, certainly in my practice, an awful lot of allocation hearings specifically focused on the intermediate track allocation in terms of the bands. But it does seem to me, and the feeling I'm getting from talking to our practitioners, is that band 3 is going to be somewhat of a starting point argument for many cases if they don't blatantly fall into band 2. And let's not forget, band 1 is really quite prescriptive in terms of how you're getting to band 1. Really, it's going to be between 2, 3 and 4 in the large majority of cases. So I've done the example, as I've said, on a band 3 case. I've done the maps looking at the table at the practice direction, and we have just about £46,000 of costs there in an example where the offer expires between witness statements and experts. So the claimant will get 35% of stages 6, 7, 8, 9, 10 and 11. Now, before the percentage valued uplift, potential of permutations, for example, not completing the bundle, is a reduction or an addition depending on who's done what. That's essentially the lowest figure it could be, I think it's fair to say, or slightly with potentially not the bundle, but that's a small amount in comparison. So £46,000, as you'll see on the slides, at 35% is £16,000. I would of the opinion that is something that can be relied upon when you're advising clients a band 3 intermediate track case, knowing that you'll get that £16,000 or possibly a good significant amount more straight, pretty much with good prospects of having that, is a really good thing to be able to advise your client. So this, in terms of how it differs from the usual 36 regime, is a really important point, and one which, rather than having to advise your client on how indemnity costs work and how it's all sort of somewhat shrouded in mystery, you will be able to point to an exact pound and pence figure in terms of what the consequences will be. In terms of one of them will be, as I've said, the other ones are still at large. So this is something I picked out as being relatively significant and hopefully relatively helpful to all involved. But again, it makes sense because the indemnity costs wouldn't work, and the figure of 35% has been arrived at. I don't know how. I'm sure a lot of thought and consideration and data went into that, or maybe that's just me being naive, but in any event, that's where we are. So that, at a bit of a canter, is the key differences, I say, and the key things to be alive to when being on the intermediate track and dealing with Part 36 offers. Of course, the intermediate track is just springing into life, and as things go on, there will be landmark authorities come out on exactly how this works, and it may be that certain observations I've made don't stand up to those authorities. We'll have to see, but at a brush, that is the difference. Those are the bits of the provisions that you need to be reading twice over before advising your clients, so you know exactly what the consequences will be. So that is the first half of today's talk in respect of the intermediate track. The next one is part 2 in respect to invalid offers. Now, what I'm going to do in a moment is run through an example of a, inverted commas, Part 36 offer and look at the basically issues with it. But I think it's so important to open that whenever you have a Part 36 offer that isn't a Part 36 offer that's invalid, it can still be considered in the usual way under CPR 44. An interesting case to look at in that respect is F&C Alternative Investments Holding versus Bart Bellamy. A 2012 Court of Appeal case, as you'll see. This is a really interesting case. First and foremost, it puts beyond all doubt that not valid Part 36 offers don't just fall away into the abyss and not be considered. They are to be considered under CPR 44 in the same way as any other offer. So essentially, the way I think about it and the way I advise clients is they essentially become Calderbank offers straight off the bat, and they will fall to be considered. But of course, under 44, the judge's discretion is wide, and we can't offer the same assurances that they will be considered as they are considered under 36. So that's the key difference, but they're still considered. Now, the reason I say F&C Alternative Investments is an interesting case is because in this case, without getting bogged down in the actual facts, what occurred was there was an offer that I think on reading the case didn't even really purport to be a Part 36 offer. But the trial judge found it to be analogous to a Part 36 offer, essentially said, well, it's basically the same thing, and awarded consequences as if it were. So what the judge did was, off their own back, went off and said, well, I'm going to treat this as a Part 36 offer when it isn't, and award those costs. If this ever happens to you, a judge takes it off and thinks, well, this is either so good or so poignant that I'm going to treat it as a Part 36 offer and follow those provisions, print off a copy of F&C and hand it up. Because what happened was, on appeal, the judges on appeal, the Court of Appeal, said, well, no, Part 36 is a strict code of a strict form and content, as we'll come on to look at. And the Court of Appeal said, no, you can't just loosely go around sort of anointing Calderbank offers as Part 36 offers, because one could see an analogous link between the two. Essentially, it was nipped in the bud any idea that the Part 36 regime could sprawl out and be of application to non-conforming, invalid offers. So then the Court of Appeal said, well, it isn't a Part 36 offer, so the judge had no jurisdiction to make an order under 36. So they said, well, the discretion in that case found, especially in terms of indemnity costs, that the discretion was just under CPR 44. And thus, what I'd say is one of the headlines that you can't consider it under CPR 44, because that's exactly what the Court of Appeal said. They applied the provisions of CPR 44 and essentially said under those provisions, the judge's decision was wrong. So that, I say, is a brilliant sort of benchmark post to look at in terms of where we are with Part 36, when it should apply and where it doesn't apply, that it puts us in CPR 44. So taking that into practical terms then, don't be relying on your fantastically worded Calderbank offer letter and having such weight that you'll be able to convince the judge to treat it as a Part 36 offer. You may well do. You will be vulnerable to a appeal, potentially. And likewise, if you do make an offer that you later down the line, you look at again and think, oh, that might not be quite Part 36 compliant, Don't worry, all is not lost. It will still be in the mix when the judge comes to consider CPR 44. So, moving on then, a working example. This is an example of a dispute, and then in a moment we're going to look at the offer that was made and essentially point out some flaws with it. So, claimant claims £100,000 from the defendant on the basis that D supplied window frames which were not fit for purpose. So, a straightforward, ordinary commercial dispute in all intents and purposes. The offer that came in this hypothetical situation is that the defendant would pay. It was a claimant offer. Defendant would pay £99,950, so a whopping 50% discount. But the claimant would only see 50% of its costs. Alternatively, the claimant would accept the defendant attending site and remedying the issues and installing a further 100 windows free of charge. And the offer is made under 36 and is open for at least 21 days. So what we're going to do now is run through some serious issues with this offer in terms of its validity. And those at home, you may already be looking at some things here and thinking that clearly can't be right. But I'll take them in the order that I spotted them or I dealt with them. So first of all, the first one is that the offer contains terms as to costs. And essentially that means that it's not a valid Part 36 offer. So the headline here is, leave costs well alone. Let the Part 36 provisions do their job. Don't try and meddle, because you will likely find yourself on the wrong side of this decision or some other similar decisions. I mean, if we look at this decision, it was a High Court decision. His Honour Judge Paul Matthews, sitting as a judge at the High Court, found and basically looked at the different authorities, and what was said by the other side was, well, these, I should say, in the 1990 case, what happened was they offered better terms as to costs than what would have been applicable under Part 36 to the accepting party. So they said, well, hold on, surely it's within the spirit of the CPR and everything to offer a better offer than what Part 36 would have given. Surely we shouldn't be penalised for giving the other side a better offer than what would be on Part 36. I think it's fair to say that His Honour Judge Matthew, really put some weight into that and gave it due thought. But essentially, the decision came down against that proposition, and it was held that where you put provisions as to costs, it will not be a valid Part 36 offer. And you can see the analysis there on the slide there, and it was said that it was such a conclusion would run contrary to Mitchell and James, French and Group Armour, and that these things shouldn't be contained. The second one, issue 2, going off piste, as I've named it there. We'll see from the offer, if we flip back to it, it's C. Alternatively, the claimant would accept D attending site and remedying the issues, providing a further 100 windows free of charge. An offer which advances a basis that's outside of the pleaded case will not be a Part 36 offer. And again, if we look at the finer points of that judgment, it says there, and it's the last part, the Court of Appeal decision, Headland Saunders, is authority for the proposition that words claim, parts of claim and issue are referring to pleaded claims, parts of claims or issues, and not other claims or issues that may have been intimated in some way but never pleaded. So looking at the case at Woodgate and Woodgate, what it was, the claimant and defendant were brothers. The defendant was the personal representative of their mother's estate, and the claimant didn't like this. The claimant claimed the remedies in terms of removal of the defendant, appointment of an independent administrator, and an account of the estate. So that was that. That was what was pleaded. Straightforward remedy in this area of law. But the claimant's Part 36 offer was for the defendant to to pay him £350,000 or thereabouts for his 50% share. So it was a straightforward buyout of his interest in the estate. The judge in this case held, no, that is not a Part 36 offer because it falls well outside of the regime. Looking at that, how that affects us in day-to-day practice, I see this most commonly in property disputes, especially in your rights of way, sort of boundary disputes. Often it will be the location of a fence or something like that. And the pleaded case is literally a determination of the boundary and an order that they remove the fence in its simplest terms. What you tend to get is when you get two warring neighbours, that all these other issues are at play in sort of the background, that often they're included in letters of claim. And, as soon as they fall out about the fence, it's then said, oh, well, your security light's facing to our kitchen, your CCTV's facing the wrong way. All of that sort of things pop up. And often parties seek to make Part 36 offers that are all encompassing, that deal with all of the points and essentially try and tidy up the parties' relationships and sort of going from top to bottom, dealing with everything that could possibly be in dispute. That will not be a valid Part 36 offer unless there is a pleaded case as to the location of the CCTV or as to the angle of the floodlights, etc., etc. You have to stay within the provision of the pleaded cases. So what you can quite feasibly do is make a Part 36 offer on the Monday in respect of trust, the pleaded issues, but then make a Calderbank offer on the Wednesday that week, and basically then covering everything you like. Of course, Calderbank offers, you have that bit more freedom. It's not to say that a judge won't look at a Calderbank offer that's so broad and say, well, I can't really consider that with the same weight as a narrow one. The judge may say that, but rather than not being a Part 36 offer, it will still be Part 44 in the usual way, and it might just give the parties that flexibility. So rather than having one offer as a purported Part 36 offer that isn't a Part 36 offer, you will have a valid Part 36 offer and the offer you really want to make in the form of a Calderbank offer as well. And so they can both be live at the same time. So again, it starts getting complicated because the client will say, well, what if we accept the first one, not the second one, etc., etc. But that's unfortunately just a necessary evil of trying to stay within the provisions of CPR Part 36. Issue 3, it says there at least 21 days. This is arguably a breach of 3651C because it does not allow the recipient to ascertain the exact expiry date of the relevant period. As we've just been looking at, and whether you're on the intermediate track or just at large on the multi-track, the date on which, or indeed the fast track, the date on which the relevant period expires is the benchmark on which we make all of our arguments on the quantification of costs. So any offer that isn't clear about when that will be can't be an offer because it can't be applied later on. It's simple stuff, but it's easy to miss. Indeed, it has been missed in cases, and it will be missed. So please do keep an eye out for that one. The last one we may be pleased to hear is a little bit more complicated, and I think I'll hazard giving the opinion that it's a little bit more interesting as well, and that is whether or not it's a genuine attempt to settle. Now, this is, I should say, not a straightforward suggestion of whether or not it's a valid Part 36 offer. This is more, well, it's not more, it is a question of whether or not you will fall foul of the provision that it's unjust to award that amount in light of whether or not it was a genuine attempt to settle. So if the judge finds that it's not a genuine attempt, they may say, well, it's unjust. And this is to cover a situation where at the outset of proceedings, a party makes a Part 36 offer basically saying, well, accept the full amount we're claiming or else. So it's an all or nothing sort of offer. So again, that was the question in the yield point case. But how will that work? At what point will a judge say, well, that's not a genuine attempt to settle the case. Yield point sought the sum of £4,950,000 inclusive of interest, and that sum represented 99% of the principal claim. And then there was a complicated question as the rates of interest applying at various times, but essentially the Part 36 offer represented about 96% of the claim value. Now, the judge in the yield point case essentially said, no, this is not a genuine attempt to settle the proceedings, and basically found it was unjust to apply the Part 36 consequences. So is that a authority that we can point to that anything in or around 96% will not be a genuine attempt to settle? No, it's not. Unfortunately, that would be far too straightforward. Indeed, the yield point decision looked at the other authorities. 99.7% offer in Rawbank and Travelex, or the 95% one in the Jockey Club case, or indeed the 9% one in JMX. They were found to be genuine attempts. But the judge said, well, that does not dictate how I decide this one. It only provides illustrative guidance. It went on to look at themes, is that you have to look at the way the offers could be characterised at the time of the relevant offer. And it references that the case of Rawback there, what was going on in that particular case, and whether or not a lot of the focus there was on the credibility of the defence put forward at the time. And of course, the poorer the defence, the more likely that a high offer is more of a genuine attempt to settle. But it has to be objective, conducted free from the hindsight gifted by a trial and its known outcome so far as possible. So what we need to do here when advising on this is really try and be frank with ourselves in the situation that we're in at the time the offer is made. Look at whether or not it's likely to be seen at that time as a genuine attempt to settle. Now, what I would say is when of course these offers are going to be considered, often with these ones that have said it's not a genuine attempt to settle, looking at the authorities and thinking about it logically, they tend to be at the start of proceedings based on, as was the case in Rawbank, a poor defence put forward. So what I would say is bear in mind that you are not going to be potentially looking at this offer until the end of trial, which may well be 12 months, 18 months' time. So practically speaking, if we do make a high Part 36 offer, bear in mind that the counsel at trial will have to argue, this was a genuine attempt to settle. Counsel will have to do this 18 months, 12 months after, and might not have been involved in the making of the offer. So what I would suggest is just a practical point that I've considered, is make a detailed case note at the time. Explain in as many words why at the time it was considered to be a genuine attempt to settle, and really explain all of your reasoning, basically show your workings out, because that will be something that the counsel at the trial will effectively be able to refer back to, may even be able to read it out in as many words, and that will be extremely helpful for them. So bear that in mind. It might just make the difference between that offer being checked as a valid offer, well, not a valid offer, being given the consequences, and won't. So that is the last point. There are questions that have been put in. What I will say is that unfortunately we am running out of time. I was told to keep it under 40 minutes. I think I may have already slightly strayed or be close to straying. So what I would invite you to do is, if you do have any questions, you will have a feedback form at the end. Feel free to put them in the feedback form, or email one of the clerks, and they can get it to me, and I can get back to you. So I'm more than happy to do that. Or if you've got a pen handy now, my email address is hdyson@kingschambers.com. So thank you everybody for listening. In terms of what is up next in the commercial series, 9th of July is the next instalment with Andrew Grantham on Freezing Injunction, and then the 11th with Neil Berrigan and Douglas Cochrane on Without Notice and Full Apparent Disclosure, and then on the 17th we have Mark Harper Casey and Gina Renales Kotos on protecting confidentiality and privacy in injunctive proceedings. And so hopefully I'll see you all logged on to those. But otherwise, thank you for attending today, and I hope to see you all soon.